Hello, my name is Michael Busby. I am a family law attorney in the state of Texas who practices family law in Harris County and Fort Bend County, Texas. Putative marriage is a marriage contracted in good faith and in ignorance on one or both sides, for which impediments exist that render the marriage unlawful. Putative marriages are attempted marriages which are contracted in good faith by at least one party, but are void because of an unknown obstruction to the person claiming to be a spouse. The purpose of the putative marriage doctrine in Texas is used to correct an injustice which might otherwise occur if a marriage is believed to be valid by one or both of the parties, but deemed void. As such, the doctrine works as a protective mechanism for the innocent persons. The critical distinction is that the marriage itself is not rendered valid. Rather, the doctrine allows the innocent party certain rights in the estate created during the relationship. A putative spouse has all the rights, incidents, and privileges pertaining to a legally valid marriage, including the right to an equitable division of all property acquired during the relationship in a suit for divorce or a suit to declare a marriage void. As a putative spouse, a party has the same rights in property acquired during the relationship as a lawful spouse. The property rights of a putative spouse are limited to the property rights acquired during the putative marriage. A putative spouse has no right to any share of the property in which their purported spouse had at the time of the putative marriage, whether that property was separate or community. However, a putative spouse has the right to assert claims of equitable reimbursement. The conditions that give rise to a putative marriage. The question of whether a putative marriage exists commonly arises in two circumstances: as a result of a divorce proceeding where one spouse challenges the validity of the marriage, and as a result of the death of a spouse where a putative spouse has a legal spouse claim survivor rights in the estate of the decedent. The requirement of good faith. This is an essential element of a putative marriage is good faith. However, it is noted that good faith is presumed. Clear and positive evidence is required to overcome the presumption of innocence to support a putative marriage. As long as the good faith spouse remains ignorant of the impediment, a putative marriage exists. At any time there is a claim for a common law marriage, it will be important to also consider the concepts of a putative marriage. An invalid common law or informal marriage, if entered into in good faith by one or more of the parties, may serve as the party's justification in asserting rights as a putative spouse. Both an informal marriage and a ceremonial marriage can be the basis of a putative marriage. The following factors may be considered: whether a purported spouse to a putative marriage has a good faith belief in the validity of the marriage, the purported putative spouse's age, life experiences, and level of sophistication, the purported putative spouse's proximity from the jurisdiction to the purported divorce, the purported putative spouse's citizenship, status, nationality, his or her birthplace, whether the putative spouse is pregnant, the putative spouse's understanding of the familiarity with marriage and divorce requirements and laws, whether the putative spouse received assurances from the other spouse concerning their marital status, marriage documents, testimony, and whether the parties involved have been living together as husband and wife. The impediments that give rise to a putative marriage are going to be commonly the existence of a prior marriage to a third party. Termination of a putative marriage. As with other marriages, a putative marriage terminates by the death of either party to the marriage. A putative marriage also terminates when the legal impediment to the validity of the marriage is removed. Thus, if the spouse who was married to someone else becomes divorced, or that other person who is married to one of the spouses in the putative relationship passes away, then that would remove the impediment such that the putative marriage would now become a valid marriage. The rights of a putative spouse, other rights than the right to the property division, would be inheritance rights. The surviving putative spouse cannot inherit the other spouse's separate property unless the will so specifies. When a putative spouse's partner dies intestate and the decedent has a surviving lawful spouse, the putative spouse is only entitled to 1/2 the interest in the marital property acquired after the inception of the putative marriage, constituting the decedent's estate. The surviving spouse right to the estate of an in-state spouse dates only from the date of the ceremony if the putative spouse is based on a ceremonial marriage, or from the date of the agreement to be married if the putative spouse marriage is based on common law or informal marriage. For homestead rights, as with other citizens of the state of Texas, a putative spouse having an interest in property is entitled to claim homestead rights as a single person under the Texas Constitution. My name is Michael Busby. If you like, please subscribe, and thank you for watching my video.